Good afternoon. Today is Tuesday, October 1st. It is 4:17, and I'm calling this regular monthly meeting of the Planning, Programming, and Zoning Commission to order. Looking for a motion and a second to approve the agenda.
So moved. Second.
First and second, all those in favor?
Aye.
Opposed? We have an agenda. We're looking for a motion and a second to approve the minutes from last month's meeting.
So moved. Second.
First and second, all those in favor?
Aye.
Opposed? Minutes are approved. Financial report is right on target. I think we've all had an opportunity to look that over. Looking for a motion to receive and place that on file.
So moved.
Second.
First and second, all those in favor?
Aye.
Opposed? Is there anybody in the audience that would like to speak about an item that is not on the agenda this evening? Okay, seeing none,
For someone on the agenda?
something that's not on the agenda, okay? Seeing none, we're going to move to the first item on the agenda, and this is a hearing, and the time is 4:20, and a hearing is scheduled at this time, and we'll take our staff report.
Okay, the request to rezone approximately 1 acre from R2 1 and 2 Family Residence District to R2 CZ Conditional Zoning District at 114 Monroe Street. The purpose of the rezone is to legally reestablish an existing truck repair shop. The site is predominantly surrounded by residential uses with the exception of a convenience store zone C2 Commercial District located to the immediate southwest. It would appear that the rezoning of the property to C2 CZ would not have a negative impact on the area as the building has existed since 1961 without any noted issues. Site in question is served by Nevada, Monroe, and Polk Streets, which are considered local streets. There are sidewalks along Nevada, Monroe, Polk streets, and off-street parking is available. Therefore, it would not appear that there would be a negative impact on the traffic in the area. Dubuque Road to the south is classified as an arterial collector street. The proposed rezone area is currently zoned R2 1 and 2 Family Residence District and has been zoned such since the adoption of the ordinance in 1969. The surrounding area is comprised of R2 1 and 2 Family Residence Districts or dwellings, with the exception of a convenience store to the southwest. The homes in the area were built in the early 1950s. The existing structure was built in 1951. Our staff will be recommending that there be screening required as a part of this request. The proposed rezone would comprise of 1 acre to be purchased by the applicant. The structure was built in 1961 before the adoption of the City of Waterloo's zoning ordinance. Ruin Trucking owned the site from 1999 to 2012, but vacated the building in 2012. The site was grandfathered in, but has now lost that grandfather status as it has been vacant for 12 months or more and is now considered an illegal use in the R2 1 and 2 Family Residence District. Therefore, this rezone request is an attempt to legalize a commercial use in a district that does not allow retail or any commercial uses. Staff is supportive of infill development and smart growth principles as outlined in the comprehensive plan. The proposed zoning would work to reestablish commercial presence in a vacant commercial building while also limiting the commercial uses so it does not jeopardize or harm the residential neighborhood surrounding the site. The CZ conditional zoning classification works to allow uses in unique locations or transitional sites between different land uses. This site is definitely unique in its history and location. Therefore, our staff recommends the request to rezone approximately 1 acre from R2 1 and 2 Family Residence District to C2 CZ Conditional Zoning District for the purpose of reestablishing a commercial use at 114 Monroe Street be approved for the following reasons. The use at the site will be limited to a truck repair unless the owner comes back before the Planning Commission to change the use. The proposed commercial use has existed at the site for 40-plus years and has not had a negative impact on the surrounding neighborhood. The proposed rezoning would work to reestablish a commercial presence in a vacant commercial building while also limiting the commercial uses so it does not jeopardize or harm the residential neighborhood surrounding the site. And subject to the following conditions, that there be screening along the easterly property line from Monroe to Polk Street, and that the office/trailer be removed from the site, as mobile trailers are not allowed outside of mobile trailer parks in the city of Waterloo. Any questions for staff?
Yep. We also need to place a statement on file, verification signed by Patty McGee, stating that she sent a certified copy of the attached letter to all the area residents. So if we could have a motion, a second on that.
So moved.
Second.
Okay. All those in favor?
Aye.
Opposed? Okay. If there's anybody in the chambers that would like to speak for or against this hearing request, please come to the microphone, state your name and address. Okay, seeing none, any discussion from the board?
Move to approve the rezoning request.
Close the hearing, close the hearing.
Oh, I'm sorry, yep. It is 4:25, and the hearing is now closed. Looking for a motion
Close
to
the
close.
hearing.
Second.
Second, all those in favor?
Aye.
Opposed? Okay, hearing is closed.
Now I would move to approve the rezoning request with the conditions.
Second.
We have a first and second, all those in favor?
Aye.
Opposed? Okay, that hearing request passes unanimously. Okay, we have another hearing at this time. And time is 4:26, and the hearing is scheduled at this time, and we want to receive and place on file a statement of verification by Patty McGee stating that she sent out a letter to all the area residents on September 20th through regular mail. Can we have a motion to place that on file?
So moved. Second.
First and a second, all those in favor?
Aye.
Opposed? Okay. Staff report.
Andera staff, this is a request to rezone approximately 1.31 acres of land from R2 CZ Conditional Zoning District to C2 Commercial District. Applicant is BCS Properties LLC. Would not appear that the rezone would have a negative impact upon the surrounding area or other surrounding land uses in the area. Rezone in question is zoned R2 CZ and has been zoned as such since November 8th, 1993. Land was rezoned to conditional zoning district to allow for the establishment of a new golf course upon the site, as allowance of the commercial golf course was not permissible in the A1 district or an R district. Surrounding land uses in their zoning include, to the north, existing golf course zoned R2CZ, and 1 and 2 family residences along Jane Street zoned R2. South is United Medical Park zoned R4CZ. East is existing commercial development zone C2, and west is vacant development ground zone A1. Surrounding area is mostly comprised of professional office and some commercial development. There is 4-inch drain tiles located within West Ridgeway Avenue, along with a 10-inch sanitary sewer to the south of the site in question. There are multiple culverts located in the area near the rezone. As noted, the site consists of 1.31 acres of land and is located on the north side of West Ridgeway Avenue between Highway 63 and West 4th Street. Applicant is requesting to rezone the property for the purpose of making the site suitable and marketable for new commercial development adjacent to the existing golf course and driving range. Rezoning area in question is located directly to the west of land that is already zoned C2 Commercial District. It would appear that rezoning the land would be beneficial to the surrounding area, as it would open up additional ground for new commercial development along a heavily traveled corridor. Staff feels this particular location for commercial zoning would be appropriate, as it is directly across the street from professional office development, which appears to be commercial in nature. As the site is developed, it would appear that the commercial development would blend well with existing development in the area. Staff recommends that the request to rezone from R2CZ to C2 Commercial District be approved for the following reasons. Site in question would appear to provide sufficient space to meet all required regulations, including setbacks, drainage, landscaping, screening, etc. It would not appear that rezoning the land to C2 would have a negative impact upon the surrounding area, as rezoning of the land would appear to fit the character of the surrounding area that is primarily professional office and commercial in nature. And 3, the rezone area is in compliance with the comprehensive plan and future land use map for this area, which designates it as business park, professional offices, commercial, and compatible light industrial. and is located within the primary growth area. Any questions for staff?
Okay, would anybody in the chamber like to speak for or against this request? Okay, seeing none, in discussion by the board members?
I'd move that we close the hearing. Second?
First and second, all those in favor?
Aye.
Opposed? Hearing is closed.
I make a motion that we approve the request.
Second.
First and second, all those in favor?
Aye.
Aye.
Opposed? Okay, the request passes unanimously. The next item on the agenda is a special permit request by Muhammad Shabazz for a special permit to establish a non-limited alcohol sales use at 821 Broadway Street. Staff report.
This is Schrader with staff. The applicant owns the property at 821 Broadway Street under the business Eagle Corporation and has operated an alcohol sales use business or leased the premise to business partners to operate an alcohol sales use. The site operated as an alcohol sales use with a Class E liquor license since prior to the first zoning ordinance amendment in 2009 that affected alcohol sales uses, and had previously never been classified as to a particular type of alcohol sales use. As provided by the zoning ordinance amendment number 5126 adopted August 20th, 2012, the use was classified as a limited alcohol sales use off-premise consumption. As provided by the ordinance, the applicant requested reclassification as a non-limited alcohol sales use off-premise consumption, but has failed to provide necessary documentation to substantiate their request for reclassification. Therefore, the applicant's requesting the special permit and variance approval to allow the business to be reclassified as a non-limited alcohol sales use. Absent such approval, their request for reclassification will be rejected, and the use would be required to comply with the requirements as a limited alcohol sales use, including requirements to provide agreements as such, meet sales requirements as such, floor space requirements, and signage requirements. The applicants are suggesting that they have historically operated as a non-limited use, a liquor store, but have indicated that they do not have the sales data required to document their previous status as non-limited. The request could have a negative impact on the surrounding area. The intent of the alcohol sales overlay district is to avoid undue concentration of alcohol sales uses in targeted areas of the city and to prevent the expansion of legal nonconforming uses within the overlay district. The use in question would be considered a legal nonconforming use regardless if it is classified as limited or non-limited, but staff is concerned with the precedent for allowing a limited use to be reclassified as non-limited use due to inability of the applicants to properly provide documents. On September 24th, 2012, staff sent a letter to the owners of Broadway Liquor at 821 Broadway Street indicating the use was being classified as limited and as provided the details on the process and timeline to request reclassification. On October 5th, 2012, the applicant submitted a notice of intent to request reclassification, and on October 24th, 2012, submitted that request for reclassification, including some required sales data. However, the sales data was not sufficient to substantiate the request for reclassification. Staff has been working with the applicant and the applicant's attorney since that time to secure documentation sufficient to substantiate the requested reclassification, but have not received the required documentation. The applicant has indicated that they do not have any further detailed sales data and have opted to request the special permit and variances to establish the non-limited use. Therefore, staff recommends that the request for the special permit to establish a non-limited alcohol sales use off-premise consumption at 821 Broadway Street, an existing use requesting reclassification as non-limited, be denied for the following reasons. Number one, the request would appear to have a negative impact on the area. Number two, the request could set a precedent allowing similar uses to request reclassification. And three, There does not appear to be a lack of reasonable return, as the property can continue to be used as a limited alcohol sales use. Any questions for staff?
Yeah, in a nutshell, what is the difference again between the non-limited and limited, just in layman's terms?
A limited alcohol sales use off-premise consumption has to limit their total alcohol sales to 40% of their gross revenue, excluding tobacco, lottery, and gas product sales. They have to limit their hard liquor to 25%. They have to limit the total retail floor space to 25%. They cannot have signage that uses the words beer, liquor, alcohol, and other things of that nature. Those are the main ones.
Any other questions for staff? Would anybody in the chamber like to speak for or against this request? If you would, please come to the microphone, state your name and address, please. Excuse me, would you please come to the microphone and state your name and address? No, this microphone right here.
The applicant have question to
Excuse me,
counsel,
your name and address, please?
I'm here as a translator, he's my cousin, so he has a language barrier a little bit, so that I'm here
Okay.
for translate, And his name is Muhammad Shabazz.
Okay.
And address is 821 Broadway.
What's his residence?
What's your?
It's
phone?
3449 Cedar Terrace Drive.
Cedar Terrace Drive?
Yes,
Okay,
sir.
thank you.
Well, he has a question, that to counsel, he's been running, first he was leasing the store and he's been running the store 8-9 years, and when he got that store and he got basically non-limited alcohol and he been selling alcohol, the name is Broadway Liquor, and suddenly this ordinance and regulation, what he reviewed, he been passed, and there is no way for him to get the 60% the other merchandise than alcohol, but how he can customer come and how he can say to customer, I already 40% and I cannot sell you if the customer come to buy the liquor, So that's his question, like that been 8-9 years he's doing it, and suddenly that he cannot make it, that 40% and 60% come up, so he's requesting to, it shouldn't apply on him, because he's been running 8-9 years, so he didn't know that, that's going to be happen, rule and regulation going to be passed, so he's requesting, so he should grant a permit for him.
Thank you.
So can I understand correctly that from what this gentleman has just said, that for the past 8 or 9 years, they have been out of compliance by selling more than the 40% if they're limited liquor?
That is incorrect.
Okay.
So prior to 2009, the zoning ordinance did not have much of any regulations specifically geared towards alcohol sales uses, and there really wasn't anything that would distinguish a liquor store separate from a convenience store, separate from a grocery store or a pharmacy. All of those were considered permitted uses, generally speaking, in a C2 commercial district, some of them in a C1 commercial district. So prior to 2009, those uses were permitted in the C2 district and there was no classification. In 2009, they changed the ordinance and created basically a couple of tiered system, but even with that 2009 amendment, there was nothing that addressed uses that were established before that date and having to get them classified as one or the other. So in August 20th of 2012, the City Council passed an ordinance that did just that. It said all uses shall be classified, and it outlined how they were to be classified, including having to provide sales data and absent sufficient data that shows that they previously have operated as non-limited, their default classification, so to speak. is the limited category, and they've got to request reclass as non-limited, but they've got to provide the sales data. That's where they're running into problems. They've provided some sales data. It's very generic. It doesn't have any details, so it was deemed not sufficient to substantiate their claims. We've been working with them to try and provide additional detail, but they've said they don't have the sales data. They didn't have the detailed information on the sales records, so they're opting to just request the special permit and variances.
Thank you.
Well, he's admitting, you know, so his alcohol sale is way more than 60% even, you know, that in that store, you know. So he couldn't qualify for that, you know. He have like couple shelf candy and chips, you know, so you taking out tobacco and lottery, everything. There is no way he can come up with the 60%, you know. So it's mean 8 and 9 year, I understand, you know, that rule regulation just came, you know. What that mean, you know. So it's a new regulation comes, so he should close the store. He has built the store, he's been working at the store, you know. And also that he has a, whatever the sales he gave me, recent that he was leasing before, you know, so he just took over, you know. So even the recent for 5-6 months, and I've been seeing even the 5-6 months, the alcohol sale is more than even 60%, you know. So what is the solution, you know, like anything?
I have a question. When I read through this, because I've owned 5 businesses here in Iowa, from the west side, the east side, and I noticed going through your records that you had, you've been in business for 8 to 9 years, but isn't it correct? Don't you have to file your sales taxes?
Oh, yeah. Well,
So
yes.
I had trouble finding, why is there no documentation provided for us? So that
Well, he
means,
can provide the
actually,
document, even that the previous document, you know, his sale is more than 60% even alcohol sale, you know.
but looking at, forgive me for interrupting, I'm just trying to kind of get to some of the points that I would like to have clarified, is the documentation required, one of them was from a CPA. Now, I looked under James Morrissey, he is not a CPA, he's a
Right,
tax
right.
preparer, and the outlines, it looks like you were given 12 months to comply. I guess I'm having trouble understanding why it is taking so long to comply documentation that should be on your records for a minimum of at least 3, if not 7 years. There should be information in your bookkeeping, whether you're on computer or even handwritten ledger forms. There should be cash flow statements. There should be profit and loss, income, and all of that information should show specifically, you know, what those totals are. And according to the documents I've seen, it's basically just written down or just this and that. But I think the law, I feel, is very clear, and I think 12 months should be an ample time to be able to provide that for the city. So that's why I am siding with the city on this. I think you need to provide that information, because otherwise the law is very clear, and 12 months seems like a very fair time to ask for those documents.
But what reason that the CPO, that Jim Morris, you know, he filed his taxes, you know, everything, and it's IRS, you know, that he's filing the tax, you know, so why he has a question, why is council and that they are not accepting the Jim Morris?
Actually, one more question I have. Like to last 3
You can
years,
explain me, I can tell them.
last 3 year I was a lease on someone else's same
Well, I explained
location.
them already.
And previous one, like to who's running business, he was gone last 4 months ago. And after 4 months ago, I knew like to lease.
Well,
person
he said he was
like
leasing the store.
a new person.
Before, and he just took over.
Yeah.
And the person he was leasing, he's not giving him a paperwork, you know, anything, you know.
Previous was 3 year, his lease done, he's gone from me.
So he's willing to provide this 4-5 months, he's been running that all paperwork, you know.
Who is filing your sales tax reports?
So the Jim Morris.
He's Jim Morsi, yeah.
Okay.
Yes.
Can't he turn his paperwork or his information over to CPA so
Well,
that can
according to
comply with
individual
the
error, you know,
requirements?
So they don't accept Jim Morris paperwork, you know,
But-
because he's not a certified.
He's do help on
accounting.
doing this.
But what I'm saying, sir, is to be in compliance, if you want to have this variance, would it be possible to have that paperwork taken to CPA to be verified and certified?
Yeah, that's a possibility, I think.
But is maybe last 4 months since the previous ownership is gone, who was running business, I have last 4 or 5 months like to who's Rhino running
That's
it,
what she's saying.
like to, as my wife name Rhino's business. And this paperwork we have a previous I was try, but previous whose person was running over there, he was not gave me because I don't know.
Mrs. Schrader with staff. So the ordinance has a very specific time period of data that it's looking for, a 1-year window prior to that August 20th, 2012 ordinance adoption, and a 3-month window. So what the applicant is indicating is that because there was a different person actually running the business during that time, and that that person is no longer running the business, that they don't have the data to get from that person because they're no longer there anymore. I understand that, but that is a concern with the city that, you know, because they can't provide records. There was a similar situation on a Broadway business that was when the 2011 ordinance got enacted, or was it right after the 2009, but a business moved to a different location and would not provide the records to the owner of the site, and that owner of the site ended up having to agree to be a limited alcohol sales use since they didn't have the records to provide to substantiate a claim to be reclassified as non-limited. So, I mean, I understand it puts them in an awkward position as well if they can't provide the data, but it also puts the city in an awkward position of, you know, on what grounds are we approving it and what precedent are we setting up for others requesting to reclassify. So it's a tough one.
But he's willing to provide for 5 and 6 months, and he already talked to him, certified CPO, you know, so he will, you know, do that for 4 or 5 months, you know, so that his point, you know, so that as Eric said, you know, that there is no way he can get from that person he was leasing the store, you know, he is not going to give him anything, you know, all the paperwork and the data he has it, you know. He's willing to provide since he took over, you know. He's willing to give, and he's gonna talk to the accountant, you know, so whatever. But even that for 4, 5, 6 months, alcohol sale is more than what he's saying, you know, that's gonna be 60%.
Yeah, I have a question, and just so that I'm understanding, so even if it wasn't a matter of the 4 or 5 months, are you saying it's pretty much the same amount of sales ratio?
Alcohol, yeah.
Yes, almost.
So does it really matter? I mean, if you, I mean, then you should have something in the last several years that shows a consistent pattern. So my next question is, why wasn't that or any information provided?
Actually, who was leasing, his lease is complete. And after leasing his complete, his way. Yeah.
Right now,
And I'm property owner, I'm worried about business, like to everything. I don't want to lose my, like to think which one I spend a lot of money over there, everything. And last one, like to how this person explained, like to, I don't think so, less than like to, you can say 60% alcohol, because just one shelf has a little bit candy and everything like to alcohol over there. And
based on that, you
like
can
just
only
have
provide 5
alcohol.
6 month sale
Just have alcohol.
with the regular CPA.
yeah,
That's still over than 50-60% alcohol, you know. If you're taking out the lot-free tobacco
yeah.
out, you know, so there is no way chips and candy, small convenience store
Yeah,
can
this
sell
not me.
60% chips and candy.
Have you provided any information of any time period to the city?
Well, you know, that he was with the CPA, you know, he's going to change his CPA, you know, so that hopefully that within 5-6 months, you know, the data, he can provide accurate data.
But my question is, have you made any attempt previously in the last year to submit any documentation to the city of any time period?
Last 3 years is somebody leasing on me.
No. Can the पिछले साल का कोई डाटा प्रोवाइड कीते? No.
He was leasing, like to, he was lease, like to, he was 3 year lease with me. He just, like
So
to
that
leasing
time
on
I
me.
think
That's-
that they don't require, you know.
Yeah, there was not before, like to.
So
say
nothing has been provided to the city of any period at all showing anything?
Provide some-
Yeah, which one was, have talked to Eric before?
This is Schrader with staff. The only details on sales data that was provided appear on page 26 and 27. The actual dollar amounts I've blacked out is because I don't, feel that we need to get into the records, as to what their actual sales are, but what those were in terms of percentages are listed there. So it's showing in what they submitted for the time periods requested, what they're showing for their alcohol sales as a percentage, and that does indicate that it's, over the 40% threshold that would indicate a non-limited alcohol sales use, but it's very general data. All it has is a tobacco total, a lottery total, an alcohol total, a grand total in percents. There's nothing that breaks that out, and that's what they're saying is they don't have that breakout. The person that was running the store is no longer running the store, so they can't get that breakout, and I understand that, but it unfortunately creates a problem for both sides.
I'm just asking because I just have a difficult believing that there is absolutely no records available at any time period. If you want this special variance, this bad, gentlemen, I feel that some attempt showing some record around that time period. If you've been in business from 8 to 9 years, that if I wanted a permit that bad, I know as a business owner, I would present something. And if this is all that's ever been presented to the city, I just feel that's not sufficient.
I mean, are you talking about the previous data, that when he was leasing the person that time, that 5, 6?
I'm saying right now, if you have anything, whether from the time you've taken it to any records, you can go even to the state because you have to file your sales taxes. And that's why I believe the city has given opportunity and provisions to go to certain agencies that would show a running record, especially if the business has been in business for as long as stated. That there would be a paper trail somewhere, and I just personally feel that ample time has been given to present something. And if this is all that's been presented, I will agree with the city, this is not sufficient. There has to be something on record for any legitimate business to be able to show, this is what we take in, this is what goes out for at least income purposes, tax purposes, that there would be other sources. So I know for myself, I am siding with the city on this one. I think you need to provide more information, and I think 12 months has been sufficient.
So can he provide, that during the 3 year, the person was leasing from him, so prior to 3 years, he was running, so can he provide that time, that paperwork something when he asked him that? You can skip that 3 year, because he's not going to give it,
He was asking if they provide the information from the previous owner.
That's what we requested. We requested the time period of August 1st, 2011 to July 31st, 2012 was the time period requested for the documentation. That was the 1-year time period prior to adoption of the ordinance, August 20th, 2012.
I guess I have to agree with Lynn. I think that there's, I think the route to get to where you want to go is through working with the city to provide the information that they need, not the special permit route. And, I mean, it sounds like you operated a liquor store. You still do, and you still want to. And I think the way to get to that is by providing the needed information or work out some semblance of an agreement of information that's workable for the city.
Yeah, that's what they do. So he has to create that, generate somehow, get the old leasee, he need to get contact with him, so get this paperwork, and either previous, when he was running, before he can find it that paperwork, from accountant, anybody, give it to him.
Are there any other questions for the applicants? Thank you, gentlemen. Appreciate it. Would anybody else in the chamber like to speak for or against this request? Please come to the microphone, state your name and address, please.
Good evening. My name is Loretta Murphy. I live at 812 Broadway Street, right across the street from this establishment. And I ask you to stand by your decision not to allow non-limited. The place is a nuisance. I've lived in my house for 22 years. I've never had this kind of problem except for the last few years that this place opened, and now we have a bar right next door to it. If you go down another 2 blocks, there are 2 liquor stores. Go down another block, there's another liquor store. We don't need any more in our neighborhood. That's all I have to say, and thank you. Just please stand by your decision. Thank you.
Thank you, Ms. Murphy. I must say, I live about 6 blocks from you, and I agree completely. I think we've got enough in that area, so. Any further discussion? Okay, we'll entertain a motion.
Before we make a motion, I need to abstain from this vote.
Okay. Looking for a motion.
I move that we stand by the city's request and we deny the non-limited alcohol sales for the reasons listed below.
Second.
We have a first and second. All those in favor?
Aye.
Opposed? Special permit request is denied.
It is a recommendation of the Board of Adjustment for Tuesday.
The next item on our agenda is a vacate request by Hajrudin Kantarovich. Staff report.
Okay, the applicant has recently completed the construction of a new home at 1934 Red Tail Drive, Red Tail Trail. The applicant's financial institution required a survey after the completion of the home. Unfortunately, the survey revealed that the house was built 3/4 of an inch short of the 30-foot required building line, and the applicant is now requesting to vacate 3/4 of an inch of the building line, 3/4 of an inch of the building line, so that as to make the home legal. Therefore, staff recommends the request to vacate a portion of the 30-foot building line to be approved for the following reasons. The request to vacate would not appear to have an adverse effect on the neighborhood, as it cannot be detected by the naked eye that the house is not at the 30-foot building line. Any questions for staff?
Okay, any discussion? If there's no discussion or questions for staff, we'll look to entertain a motion.
I make a motion that we approve as recommended by staff.
Second.
First and a second to approve. All those in favor?
Aye.
Opposed? Okay, that request is approved unanimously. And the last request is also vacate, a request by BCS Properties. Staff report.
All right, the proposed vacate area is about 818 square feet located along the north side of Ridgeway Avenue. I won't go into a lot of details about the request because Tim covered it with the rezone. It's the same property as the earlier rezone request. They're proposing to construct a new multi-use commercial building on the property. As part of that development, they're proposing a new parking lot to be constructed along the south side of the property. The right-of-way does make a jog to the north along that west end of the property, and the applicant's proposing to vacate a portion of this area in order to construct the parking lot and maintain the minimum 5-foot setback requirement that is required from a parking area to a property lying along West Ridgeway Avenue. They will also be extending a sanitary sewer line that will be coming from the west to the east to serve this development. It may come into a portion of this vacate area, therefore engineering will require an easement over the portion of the area that the sewer might be extending into. The applicant's talking with the engineering department about potentially moving that sewer line more to the south. They're still in discussions with the applicant's engineer about that, which would get it out of that vacate area and would not require an easement. So staff is recommending approval of the vacate, and then subject to the condition that a utility easement is retained over, under, and upon the west 72.5 feet of the vacated area for the sanitary sewer purposes.
This is Schrader with staff. The applicant's engineer has consulted with the engineering department just earlier today, and they are going to move that sewer line a little farther south, so it won't go through the vacate area, so we do not need that subject to a retention of an easement.
Any questions for staff? Discussion? Okay.
I'd move that we accept the applicant's application to vacate as proposed by staff.
Second?
First and a second, all those in favor?
Aye.
Opposed? That vacate request passes unanimously. Any discussion? Members? Okay, enjoy the beautiful evening. Looking for a motion to adjourn.
So moved.
Second?
First and second, all those in favor? Aye. Opposed? Meeting is adjourned.